I've got a great job. Money in the bank. Last month, someone asked if I read the Bible. The Bible? I'm successful, I'm happy. What do I need the Bible for? I can get more from the Wall Street Journal. But that made me curious. So I decided to take a second look.
I'm on my feet all day. When I go home, I just want to turn on the TV and relax. But read the Bible? All those these and thous and begats? Who wants to struggle with that after waiting on customers all day? But then a friend showed me this version written in modern English, and I was surprised.
This guy I play hoops with said I should start reading it, the Bible. Man, I said, I don't need no Bible. I mean, it just ain't cool. So he goes, I read it all the time. And he beat me by 20 points. So he gives me his Bible. I read it. It ain't hoops, but it ain't bad.
What's your excuse? Before you make an excuse to avoid reading the Bible, stop. Take a second look. Pick up the Bible for 5 minutes, and you may pick it up for a lifetime.
New York, Foley Square, Manhattan, 500 Pearl Street. He liked the joke that was on the recorder, and I heard him laughing. And I had asked for an oral argument on that crazy SAP motion to dismiss. He said that the return date was April 1st and that the motion was already taken on submission. And that's even though Judge Sweet is not in the district. He won't be in the district until May 1st. However, the SAP motion to dismiss and my opposition to it, my sort of cross motion to deny that, I should have asked for summary judgment. Anyhow, it only includes those three defendants, Rosanna, Joanne Freya, and the court stenographer, Jane Doe, Kathy Brophy, and Mark A. Guterman and Friedrich Lehrman and John Porzio have never appeared. So that's why you see movement is Glendora, Franklin, location is courtroom of the United States District Judge Suite, 500 Pearl Street, New York, New York, 10007. Return date is April 29th, 1998, Anno Domini, at noon or as soon thereafter as plaintiff can be heard. Relief requested is judgment by default against defendants Porzio, Lehrman, and Guterman. Oral argument is requested. Oral argument is also requested for April 29th. Well, that's the one he denied. Well, whatever. Law clerks can't deny things. But 1998 on motion to dismissed by defendants Rosanna Freya and Jane Doe. Legal basis of Federal Rules of Civil Procedure, Rule 55B2 by the court. Amount is $23 million in compensatory and punitive damages. The cost of this action and any further relief just and proper. Service of this notice of motion and affirmation in its support on Porzio, Lehrman, and Guterman was by first-class mail on April 20th, 1998. See Franklin Buell's affirmation of service. Supporting papers are the affirmation affixed hereto, the complaint, and reply affirmation in opposition to dismiss by Rosanna Freya and Doe. Dated April 20th, 1998, White Plains, New York. Yours in truth, Franklin and Glendora. Affirmation. Under penalty of perjury, we tell you the truth, the whole truth, and nothing but the truth, and always have. So help us God. Porzio, Lehrman, and Guterman, pursuant to Federal Rules of Civil Procedure 4D, have a duty. Here's 4D. I'll read it to you. Waiver of service, duty to save costs of service. Request to waive. Defendants have grossly, defiantly, willfully, and knowingly failed in their duty to the USA. They have not acknowledged the lawsuit. They have not waived the costs of serving summons. They have not answered the complaint. For failure to defend, Porzio, Lehrman, Guterman are in default and owe plaintiff $23 million, the cost of this action, and any further relief just and proper. The remaining three defendants have answered. Both United States District Judge Sweet and the clerk have on file the copies of the waiver forms served on all six defendants along with the affirmation of service of same. In the alternative, Glendora asks, these pages are affectionate. You know why? They're stuck on each other. In the alternative, plaintiffs plead for an order compelling defendants Porzio, Lehrman, Guterman pay $45 per defendant times 3 equals $135 in advance for service by process server. This amount due on April 29, 1998 at Plaintiff's Box 416, White Plains, New York, 10602. 8. No reply, no opposition by Rosanna Freya Doe to plaintiff's opposition of March 19, 1998. 9. Rosanna Freya Doe neglected to include a copy of plaintiff's complaint in their motion to dismiss, and further included no affirmation nor affidavits. Wherefore, plaintiffs respectfully request an order for default judgment in the amount of $23 million from defendants Porzio, Lehrman, Guterman. The cost of this action and any further relief just and proper. Dated White Plains, New York, April 20th, 1998. Yours in truth, Glendora and Franklin. $15.97 in 4.5 hours. Okay. Rosanna Freya did waive the service, and so did Brophy. Freya failed to, Guterman, Lehrman, and Porzio failed to. Now, that's one Porzio suit. That one is about, the one I just read you, is about violation of our right to due process, and is stated as equal protection of the law. It's the 14th Amendment to the Constitution of the United States. And that's really a state thing, that a state cannot fail to give you equal protection of the law. It's a good thing, isn't it? Now, there's another Porzio lawsuit, and that is in the Supreme Court, State of New York, County of Westchester. It's before it's before Honorable Louis A. Barone, a very nice looking man, quite distinguished looking. And this is another notice of motion. The movement is Glendora. The name of this case is Glendora Plaintiff against John Porzio, Friedrich Lehrman, and Mark Guterman. The location is room 1602, Westchester County Courthouse, 111 Grove Street, White Plains, New York, 10601. The date is May 7th, 1998, Anno Domini 930A, or as soon thereafter as plaintiff can be heard. Supporting papers are the affidavit affixed herein. In the state court, you have to have affidavits. What's the difference between an affidavit and an affirmation? An affirmation is just something that you affirm. An affidavit is the same thing, but it's notarized. So supporting papers are the affidavit affixed herein, the complaint, and the IFP, informer paupers, poor person. Relief requested is default judgment in favor of plaintiff for $23 million compensatory and punitive damages, $950 security deposit plus 9% statutory interest, and accounting of the interest due on 1992 to 1998 on said security deposit, prohibition of John Porzio from collecting security deposits, the cost of this action, and any other relief just and proper. Legal basis is failure to answer the complaint and failure to defend. The notice of motion and affidavit and its support were served by U.S. mail by Franklin F. Buell on April 22nd, 1998, pursuant to the attached affidavit of service, dated White Plains, New York, April 19th, Patriots Day, 1998. Yours in truth, Glendora. Under penalty of perjury, Glendora tells you the truth, the whole truth, and nothing but the truth, and always has, so help her God. The summons with notice states defendants are to answer within 20 days, not counting the day of service. The 20 days were up on April 15, 1998. They were duly served. See the affidavit of service by Franklin Buell. Defendants are in default. Plaintiff asks for judgment in her favor. In the amounts and other relief requested in her notice of motion and in her complaint. Dated White Plains, New York, April 19, 1998. Subscribed and sworn to before me the 22nd day of April. Joseph Castellano. $12.78 and 4.5 hours. Okay. How many Porzio lawsuits are there? There's a baseless action that he brought. There's Glendora versus Freya, Porzio, that went all the way up to the Supreme Court of the United States. There's Glendora versus Rosanna Washington, which is now in the United States Court of Appeals on denial of our right to trial by jury, both by state law and federal law. There's Glendora versus Rosanna Washington, the one before Judge Sweet, and that's for the violation of the 14th Amendment. And there's Glendora versus Porzio in the Supreme Court, State of New York, and that one is about he stole half of the security deposit, and he lied. He lied under penalty of perjury in the city court. He lied before God. He lied before a judge. How many was that? Did we lose count? Was it 6? 6 lawsuits because John Porzio lies, steals, and cheats. Open letter to the New York Times as to Freya sentencing landlord to 60 nights. Joanne Freya is not the heroine judge you portray her to be. She has violated several constitutional rights, yet she administers oaths to uphold the Constitution of the USA and of New York State at the induction ceremonies at White Plains City Hall, January 5, 1998. She endorsed sewer service. She forced herself on tenants over whom she had no in personam jurisdiction, and she ignored several requests for a Travis hearing. She was sued in federal court for the same. The case is now before the United States Supreme Court. If this were not enough violations of civil rights, she denied tenants their right to trial by jury, Bill of Rights, 7th Amendment, and guaranteed by the New York State Real Property Actions and Proceedings Law, Section 745. Further, she does not know the law of the Unified Court System for city courts, nor does she apply controlling law. For instance, she does not put her orders in writing. For instance, she denies litigants to hear the record on court audio tape. For instance, she shuts off the court audio tape and censors the court proceedings. Rosanna Washington, another violator of civil rights under color of state, appointed by the White Plains Common Council and mayor, is worse. Both Freer and Washington are rank ex parte supporters of Mark Allen Guterman, whom you mentioned in your January 16, 1998 Friday article. It is reasonably assumed that Freya sentenced Matai out of anger. Because Naim Matai fired Judge's pet, Guterman. Both Rosanna and Joanne are defendants in 2 federal lawsuits for civil rights violation of trial by jury. And here it is today, January 19, 1998, Civil Rights Day. September the 2nd, 1997 at 2 p.m., Rosanna Washington ruled our landlord-tenant case was adjourned pending determination of the federal lawsuit against her. When we hear from the federal court, the case will come back to this court, either to a different judge or to a different court. Yet, even with the case still in the U.S. Court of Appeals, for the Second Circuit, Rosanna Washington, or somebody, anonymously, scheduled a February 19th, February 20th trial. This is more nescience. She doesn't know what is going on in federal court any more than she knows what is going on in her own White Plains City Court. Further, when a case is adjourned, it is adjourned. Yet she let Mark Allen Gudeman submit an application to the court with no service on us to get the rent paid into court into the hands of the landlord, John S. Porzio, 2 Old Mamaroneck Road, White Plains, 10605. It was Porzio's choice to return the April 1997 rent to us, saying, quote, "You are no longer considered a tenant," unquote. Since then, we have paid the rent into court, the first of every month, and Porzio has not seen $10,500 worth of rent. He has to get the award for the dumbest litigant of all time. Guess whom he is paying rip-off lawyers' fees to? Gudeman and Friedrich Lehrman, 199 Main Street, White Plains, New York, 10601. Nearby, Joanne Freya's old office at 175 Main Street. Further, quote, "no longer considered a tenant," unquote, is litigated by a court, not a landlord. We fought hard for the Emergency Tenant Protection Act protection we just got for another 6 years against greedy, retaliatory, and harassing landlords like John S. Porzio. Porzio spit in tenants' face and on 10 or more counts violated tenants' warranty of habitability. As to right, tenant reported Porzio to the Westchester DA, the White Plains Police, the New York State Division of Housing and Community Renewal, White Plains, the White Plains Building Department. Porzio, in his rage, brought a baseless lawsuit in retaliation to evict tenant. Tenant has been able to ward off Porzio, Lehrman, Gudeman, Freya, and Washington with a sound application of the law which they failed to master. Tenants are pro se. Porzio's baseless lawsuit is a harassment, now no longer a misdemeanor under the new Emergency Tenant Protection Act. If a landlord harasses you to move or harasses you to do anything, he is in violation of the Emergency Tenant Protection Act. That used to be a misdemeanor. Now it's a felony under the new ETPA. Tenant's harassment complaint is before the Manhattan DHCR, since that is how the DHCR does things. Tenant is asking for fine and jail time. Further, Porzio has failed to obey the tenant protection laws to renew tenant's lease. The DHCR suspiciously failed to notify tenant that on November 21st the complaint was denied. Tenant checked up last week and found the complaint was speciously denied on grounds the issue was being in White Plains City Court. The issue was not being adjudicated in White Plains City Court. Lease renewal is not a cause of action, nor a defense in said court. The file tenant has on Porzio is over 40 volumes, over 8,000 pages. Who has possession of the premises? The tenant. Not Porzio, Lehrman, Gudeman, Freya, no Washington. A public record, since the whole White Plains City Court keeps theirs secret, has been made of these constitutional violations to the mayor of White Plains and to each council person, to the chief judge of the state of New York, to the administrative judge of the courts in New York County, and outside of same, to do nothing, Gary Casella, to do nothing, Gary Casella, that's his nickname, do nothing. The 9th District Grievance Committee, to do nothing in Gracia, Westchester County Court Administrator, and inter alia. It goes to Judge K, Judge Trafficante. Judge Trafficante is the administrator of the New York State Courts outside of New York City County. Lippman is head of the Office of Court Administration. And Gracia is the administrative judge for the Supreme Court, County of Westchester. Gerald Stern on the Do Nothing Commission on Judicial Conduct. Gary Casala, Do Nothing Grievance Committee. White Plains City Court, Do Nothing, Judge Freya and Rosanna Washington. Mayor Delfino, members of the White Plains Common Council, Keenan, Oliver, Melmud, Delgado, Greer, and Falcone. To Mr. Lehrman, lawyer deceitful, to Mr. Porzio, retaliating landlord, and to the Center for Judicial Accountability, and to you, Glendora TV audience. I'll show you this picture of this landlord who was sentenced to 60 nights in her own apartments. White Plains City judges should be elected, not appointed. Freer has a ferocious temper. She screams at litigants in open court. Washington has been caught red-handed in ex parte. Washington is so pro-Lehrman's Guterman, she goes Gestapo. Aside, nobody points out that Freya is Spanish for cold. Under penalty of perjury, we have told you the truth, the whole truth, and nothing but the truth. So help us God, dated White Plains, New York, on January 19th, Civil Rights Day, Anno Domini. It's always nice to have a cat's paws go into your skin. Yours in truth, Glendora and Franklin, $4 in 4 hours, and here's a picture of the landlord and the story that was in the New York Times. That's typical Freya exhibitionism. That's Al Pucci.
That was it!
That's Kevin Larkin.
Everybody get over there, get over there!
And here's somebody who doesn't live here. Here's somebody else who doesn't live here.
Come here!
They've seen the camera, and now they're gonna go hide. Sure does cut down on the noise. The time is 6:54 p.m. It is on April 18th, 1993, Sunday, and it's a beautiful day, and that's Walsh.
Now what is it?
Can I ask you to take the floor, please?
16-6.
Can I ask you to take the floor, please? Because I don't think you really have a right to take us without our consent.
Yes, she does, she does.
How do you figure that?
My dad said so. Because my
Hi, Ma! Saying that, there's no reason for that.
Jamie! 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 Jamie!
I'll rep this, I'll rep it.
Jamie! Jamie!
Go!
18!
Ma!
6!
What's me?
Let's see, there's about 6 of them. And this has been going on for an hour. Otherwise, it would be a beautiful day.
Give it to me! Oh,
I see no reason why 4 black kids should ruin
Jamie, I was wide open.
the homes of 17 families.
No! Garbage, man, travel. No, man, travel. It wouldn't be a stop, but we're allowing stuff. Yo, yo! Oh!
Up and down! Up and down!
I let go of the ball anyway.
No, up and down!
Isn't this nice to listen to this all day?
That was an up and down!
Now this one, El Pucci,
Take it over!
was out in the field this afternoon with a rifle.
I let go of the ball and the ball. You touched the ball.
Okay, fine. Fine. 18. I mean 18. 18. You're crazy. Well, never happened still. I think it was me and Fernando versus you 3.
Unnecessary stupidness. Give him a ball.
Okay, Faye. Just before 7 p.m. April 18th, 1993, Sunday. That's interesting. One boy says, you don't have a right to tape this without our consent. And the little Larkin kid says, yes, she does. Window.
Compliment, right there, compliment.
How would you like to listen to this for an hour? Every day. And more than an hour. Maybe up to 3 hours. Okay, now I'm going to take a picture of it. Andrew is one name. Kevin. Kevin's brother.
That was a foul. Come on.
There's Walsh. There's Al Pucci.
Foul. That's foul.
There's somebody who doesn't live here.
Come on.
It's Walsh. Okay, what is the date? I just called John Porzio and told him that nothing's any different. The noise is back. 4:22 p.m. on April 20th, 1993, Tuesday.
I've got a great job. Money in the bank. Last month, someone asked if I read the Bible. The Bible? I'm successful, I'm happy. What do I need the Bible for? I can get more from the Wall Street Journal. But that made me curious. So I decided to take a second look.
I'm on my feet all day. When I go home, I just want to turn on the TV and relax. But read the Bible? All those these and thous and begats? Who wants to struggle with that after waiting on customers all day? But then a friend showed me this version written in modern English, and I was surprised.
This guy I play hoops with said I should start reading it, the Bible. Man, I said, I don't need no Bible. I mean, it just ain't cool. So he goes, I read it all the time. And he beat me by 20 points. So he gives me his Bible. I read it. It ain't hoops, but it ain't bad.
What's your excuse? Before you make an excuse to avoid reading the Bible, stop. Take a second look. Pick up the Bible for 5 minutes, and you may pick it up for a lifetime.
On about February 8, 1998, Anno Domini, I received this. You remember Roberts versus Texaco, where it was clear that Texaco violated the employment discrimination laws both of the state and of the feds. And this is a settlement proposal. Now, the Roberts versus Texaco was clearly in the wrong, and otherwise they wouldn't have settled. And so they settled for $1.4 million, class action. And then a derivative action was brought by shareholders against Texaco that the board had not acted in a proper manner in behalf of the shareholders of Texaco and had not exercised their fiduciary responsibilities and things like that. I am a shareholder of Texaco, and that was a very big lawsuit. It involved, unfortunately, a lot of lawyers. The plaintiff should have gone pro se, and it involved a bad many lawyers for the defendants, Texaco. And this proposal is for settlement, and it tells all the shareholders that they can object to the settlement. And a hearing before Charles L. Bryant, United States District Judge, Southern District of New York, was held on March the 31st. In order to speak at that meeting, you had to hand in your objections, and I handed in my objections around about February 10th or 11th. Here is my paper, Multitudinous Objections of Shareholder Glendora to Proposed Settlement. And it is 24 pages long. The first thing that I objected to, of course, is the judge, Charles L. Bryant. He is the one who pushed for settlement because he didn't want the work of doing the job the way it should have been done to go the full course of the law. My second big objection is that it didn't go before a jury, and it didn't go before you, the public. The whole thing should have gone before a jury, and all of the record should have been brought in broad daylight. It should not. Some of the record was even sealed. And that is not the American way. That is not your way. You have a right to know as to what was going on there. The cooperation of the court should help the plaintiffs have discovery with a minimal cost pursuant to the United States District Court, Southern District of New York local rules, to Federal Rules of Civil Procedure Rule 23B, and to the recommendation of the Second Circuit. Videotape of deposition should be presumptively granted. Videotape depositions can be done with home VHS at little or no expense. But Bryant doesn't like to operate this way. Fifth Avenue lawyers don't like to operate this way. They are motivated only by greed. And a trial is the American way, but Charles L. Bryant is defiant of same. Charles L. Bryant has robbed me of my trial with Cablevision 3 times and of my damages 3 times. There will be an appeal. Guess who's going to appeal it? Guess who has appealed it? The risk in litigation is, so it's a roll of the dice and a toss of the coin. Litigation is because we have such bad judges and because lawyers are so crooked. The delays are due to crooked lawyers and corrupt judges. Lower level employees are, when they complain about the discrimination against the black people being done by Lundwall and Q and whereas that 3 where the audio tape was played, and then there were questions of obstruction of justice and indictments by grand jury. Not insured and no substantial assets, nevertheless they are liable. And the settlement is a cop-out. It's a scandalous cop-out. It's a rationalization, and it's typical corporate irresponsibility. It's typical lying, stealing, and cheating of corporate America today. I would like to name for you the defendants. Peter I. Bajur, John Bradamus, Willard C. Butcher, Edmund N. Carpenter, Alfred C. DeCrane Jr., Michael C. Hawley, Gillette, Franklin C. G. Jennifer, University of Texas, Alan J. Crow, Thomas S. Murphy, Cap Cities, ABC, Charles H. Price II, Mercantile Bank, Kansas City, Robin B. Smith, Insurance Clearinghouse, William C. Steer, Jr., Thomas A. Vanderslice, Maycom. He owes me something like $700. And William Wrigley, chomp, 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 little bubbles, chewing gum. I saw him at the annual meeting. I told him he made good chewing gum. He said, thanks. Edith Citron, Martin Frisch, Nathan Kaplan, and Martin H. Phillip. And they filed a consolidated amended complaint. Wanted it settled. Easy way out. It's not the American way out. And these plaintiffs, or the original plaintiffs, Roberts, and the people who were discriminated against, embarked upon one of the noblest causes of all time, of the decade. And these plaintiffs are beaten down by affluent lawyers in courts. They are little people, and they were forced to capitulate. They may have been threatened with a criminal action in violation of New York Code Rules and Regulations 1236, which could lead to the disbarment of every lawyer, and every lawyer become judge in the state of New York involved. Behind the scenes and between the lines is so obvious in this case, these 4 pages of tiny print, no margins, no double space, yea, of rhetoric, do not cover it up. It is pellucid. It is not in the best interest of plaintiffs. It is not in the best interest of Texaco. It is not in the best interest of us shareholders. It is not in the best interests of this shareholder, Glendora. And where are the compensatory and punitive damages? Texaco did wrong. They should pay. They should compensate the people that they did wrong upon. They should pay punitive damages, punishment, so that they never do it again. And anybody else in their crooked class of society never do it again. What are the lawbreakers giving the poor people whose civil rights were violated? What do the defendants have to pay the plaintiffs for injuring them? What do they have to pay to punish them? Never to perpetrate again such an offense against America. Defendants lie. This is not what Bajur said on the TV news. They know it has merit, and they are fugitives. This is boilerplate. An appeal is certain. The burden, inconvenience, and expense is inherent. Their civil rights and human rights were violated. Their record stands before God. Corporate irresponsibility, lack of accountability, the rich run away and hide. They think they are, but they're not getting away with it, folks. I know what's happening, and I'm telling you what's happening. Glendora is glad that the whistle was blown on them, but plaintiffs should have fought it out. How much do plaintiffs get? Their conscience will never be put to rest. The public acknowledges defendants' wrongdoing. They can kid everybody, they think, but in the long run, they cannot kid themselves. They know they did wrong. And they have to live with that. No fault, no liability, no damage to plaintiffs. Glendora is incredulous. No harm to Texaco, nor to shareholders? No way. This is more corporate lying, stealing, and cheating. The public is not fooled. God does not release them, nor does their conscience. They think they can fool others. They know they cannot fool themselves. Or anything else. That's outrageous. They want to be relieved for anything else. Shame on you. On December 30th, 1997, the plaintiffs should have moved for summary judgment. The lawbreakers settled because they knew that the plaintiffs had them, and because they were kicking in their shoes about discovery and disclosure. Now, they said that they made a Rule 60B motion, but they don't say what part of Rule 60B. It has about 6 subdivisions. Those mean viruses, I had to take 2 cough drops. They're worse. These viruses are worse than corporate executives. And Glendora requests the home addresses of all directors and officers. And please do not give her a hard time. It's a New York statute, business corporation law written by Governor Nelson A. Rockefeller. If a shareholder, in person or by an attorney or agent, makes a written demand on a corporation to inspect a current list of its directors and officers and their residence addresses, the corporation shall, within 2 business days after receipt of the request, residence addresses available. Guess what? It's bad enough that we have a settlement that is not representative of what should happen in America today. It's bad enough that we have a judge copping out. It's bad enough that we have lawyers whose only concern is $1.4 million getting paid. That we have plaintiffs being ripped off of their rights. But now, I make this demand on Texaco by the New York State Business Corporation law. I want these home addresses because I want to mail my objections to each one of these directors and to Mr. Bajur, because I want them to know. They think they're getting away with it, but they're not. We know. So I want to be sure it gets into their hands. So therefore I want to be sure my objections go to their home addresses. And I called Carl Davidson, who was the secretary of the Texaco Corporation, who gave me this, by the way, 2 or 3 years ago. And I asked for the home addresses. No way. Immediately we have corporate fugitivism. He starts running away. and I make it very clear, and I mean what I say, and I'm saying what I mean. And so that's the answer. So then we went over and we made our demand in writing. An assistant corporation counsel comes downstairs, and he says he's not going to sign received the paper, my demand as a shareholder for those home addresses, and also to see the books, records, and minutes by Section 624 of the New York Business Corporation Law. That's the first page. And it's the second page. And there's the law right there stated, Section 718 for the home addresses. And here is the Section 624 that a shareholder shall see the books, records, and minutes. So I said, well, I'm not going to leave it then. I will serve it some other way. And Franklin was my witness, although all the time Franklin's reading the New York Times. And then finally, he realized that I would have it served another way, and he finally signed it. So that demand was made. But I wasn't given the home addresses, so I could serve my objections upon the board of directors, and I wasn't given the books, records, and minutes. So what do? You sue. Who do you sue? It's not good grammar. It's whom do you sue? But boy, it rhymes nice. You're going to sue Mr. Bajor, and you're going to sue everybody on the board of directors. It's too bad. Here, in this settlement, they say Texaco has learned to abide by the rules of the state and the rules of the country. But they haven't learned a thing. They go out and break the laws again. Now, there's no need of that suit. Glendora plaintiff versus Texaco Incorporated, Peter I. Bajor, and Carl Davidson. And that gets more and more interesting. In the meantime, let me tell you, we went to the hearing of objectors. I said that there was a dichotomy, that they said that Texaco had done a good thing and that they were going to have a task force review their employment policies of minorities. And yet, at the same time, in the settlement, these corporate executives of Texaco, Mr. Bajor and his gang, admit no wrongdoing. Do you see the dichotomy? It's pretty obvious, isn't it? If they didn't do anything wrong, how come they're doing good now? Because of the Roberts versus Texaco and the shareholder derivative action. If they didn't do any wrong, how come out of that comes something good, the task force? So that's a dichotomy that nobody can answer. Also, this many pages were sent to us about 3 days before the March 31st meeting with Charles L. Bryant to hear the objections of shareholders to the settlement. And then another thing, they said they wanted to settle because it's so expensive, the litigation will be so expensive to go through the district court and then to go into the U.S. Court of Appeals. Well, it's expensive, folks, because of greedy lawyers and corrupt judges. If we had good lawyers and good judges, it wouldn't have to be expensive. But it's because we're paying for crooks. And then I told them that if the settlement were approved, and I was sure it would be approved, because it was initiated by Charles L. Bryan, who didn't want to do the proper work and didn't want to take the proper action that the United States of America should have seen. If it were approved, I would appeal it. So their Fifth Avenue lawyers start saying, no, they're not going to do it, and they don't have to do it, and they're a Delaware corporation. But they don't seem to realize that in the meanwhile, that Justice of the Supreme Court, John P. de Blasi, has already ruled in Glendora Shareholder versus the Board of Directors of Cablevision that this is a law, and that these corporations have to obey that law, and that John de Blasi has already ruled in Glendora's favor, that she has a right, Section 624, to see the books, records, and minutes. And this is already adjudicated. My case for Texaco is before Justice of the Supreme Court Barone. And thank you, Judge Barone, for granting my informa pauperis, and thank you, County Attorney, for not opposing it. So they come out, they realize, they try to make an offer and say, oh, we're sorry, yes, you can go see the books. But Glendora says that the litigation is going to go on. Glendora has made a demand for $23 million compensatory and punitive damages for violating a New York State statute. And so they realize that the lawsuit is going to go on, and so they make a motion to dismiss. That's the answer to Glendora's complaint. And Glendora's reply affidavit to that motion to dismiss is a notice of cross-motion by Glendora for summary judgment in her favor as a matter of law, and reply affidavit by Glendora that defendant's motion to dismiss her complaint be denied. That's the notice of motion. And now here comes the affidavit under penalty of perjury. Glendora's the only one who does this. Under the penalty of perjury, Glendora swears she is telling you the truth, the whole truth, and nothing but the truth, so help her God. And that she always has. And now, as a matter of law, Glendora exercised her shareholder right under New York State Business Corporation Law, Section 624 and Section 718. Defendants refused. Defendants chose to violate the laws of the Empire State. Willfully and knowingly, they chose to break New York State statute that this court is here to enforce. There is no dispute of facts. The record is there. Glendora made her demand in writing. Defendants' obdurate refusal arrived in writing. Summary judgment in Glendora's favor must be granted as a matter of law. It's prima facie, res ipsa loquitur. The thing speaks for itself, and it's not Italian, but it's Roman. And we also have this big point of res judicata. The matter has been brilliantly adjudicated by Cogley, John P. de Blasi, next door, in room 1201. No, he's in room 1001. When? On April Fool's Day, 1998, last week. Glendora began her inspection of Cablevision books, records, and minutes on April the 7th, 1998, and will continue until inspection is complete. We have the law of the district, the law of the circuit, now we have the law of the 12th floor, res judicata. No meritorious defense. Defendants have stated no meritorious defense, nor can they. Nobody can defend this untrammeled violation of New York State law. Article 13 is very clear that a foreign corporation, they're a foreign corporation because they're incorporated in Delaware, because Delaware has softer laws than New York. Article 13 is very clear that a foreign corporation has to abide by the business corporation law of the state of New York, as penned by Governor Nelson A. Rockefeller of Mechanical Hills Union Community Church. I used to go to that church quite a lot. The Rockefellers went to that church up in Mechanical Hills. Defendants have no meritorious defense and never can have. Glendora cannot let Mr. Block's lies stand. They must be refuted To bypass this message, press your thumb, pages 5 through 35, and index finger, and turn them as one glob to page 36 and read the wherefore. So stupid what he says, yet the shareholders pay for that. The corporate executives are lying and covering up, running away, trying to get away with no accountability. But somebody's here stopping them. Somebody's here blocking them. Now, this lawyer is one of the worst that I have encountered in corporate irresponsibility. Certainly Callagy in Cablevision was one of the worst. Block is almost as bad. On 4/6/98 Monday, Block writes a letter to Glendora. Quote, Texaco is disappointed. You are suing Texaco. Well, we'll show you the books, records, and minutes, he says. On April the 7th, 1998, Tuesday, he sends out a motion to dismiss. Now, as a shareholder, Glendora objects to paying $350 an hour for such volte-face. Another dumb thing. Mr. Blocks buys an RJI, a request for judicial intervention, for $170 when Glendora already has an RJI. I got it as an informer per pauperous, a poor person. As shareholder, Glendora objects to this profligacy, ad hominem, and no meritorious defense. How does Mr. Block's frenetic long list of exhibits of Glendora's other fights for rights absolve Texaco, Bijur, and Davidson from violating the New York State Business Corporation Law? Glendora, too, is proud of her fights for rights in America and for the Empire State. However, Mr. Block's list is woefully deficient. He's not including many of the best fights. Ipso, IFP, informer paupers, poor person release, is res judicata. It's all set. You're too late, Mr. Block. Judge Barone, Justice Barone, has already granted my motion for informer paupers.
Got a great job. Money in the bank. Last month, someone asked if I read the Bible. The Bible? I'm successful, I'm happy. What do I need the Bible for? I can get more from the Wall Street Journal. But that made me curious. So I decided to take a second look.
I'm on my feet all day. When I go home, I just want to turn on the TV and relax. But read the Bible? All those these and thous and begats? What's the struggle with that after waiting on customers all day? But then a friend showed me this version written in modern English, and I was surprised.
This guy I play hoops with said I should start reading it, the Bible. Man, I said, I don't need no Bible. I mean, it just ain't cool. So he goes, I read it all the time. And he beat me by 20 points. So he gives me his Bible, I read it. It ain't hoops, but it ain't bad.
What's your excuse? Before you make an excuse to avoid reading the Bible, stop. Take a second look. Pick up the Bible for 5 minutes, and you may pick it up for a lifetime.
Okay.
CR 97228 NG, United States versus Glendora Buell and Franklin Buell. Counsel, if you'll just state your appearances for the record.
For the government, Edgardo Ramos. Good morning, Judge.
Plaintiff, pro se, Glendora.
Stuart Grossman, legal advisor to Mr. Buell.
The legal aid decided by Jane Ann Murray, Mr. Buell.
Okay. Mr. Buell?
Franklin Buell.
Good morning, Mr. Buell. Are you in this seating arrangement that you wanted, Ms.
Yes, we are.
Okay.
Thank you.
All right. Are you ready to proceed?
Yes, what about that audio tape?
What is the audio tape?
The audio tape is by my amicus curiae, a lawyer. He says what he thinks you should do.
How long is it?
It's 15 minutes.
What does he say in it?
He says that,
What's the bottom line to what he says? What does he recommend?
well, he points out that, this is a very good statement. I didn't transcribe it because I thought we would play, but this is a very good point that he makes to you that, and you can probably say it better because I'm not familiar with it, but he said that we conform to the law of the, what do you call it? We conform to the court with the law. Because that's what we were doing on that day that we were in the Uniondale courthouse. We were solving our disputes by conforming with the law.
Okay.
And we have done public service a great deal because of the public access program. He said that Franklin has been out fighting, did fight for that, from Normandy to Weimar, D-Day to VE Day, that we are not a threat to society. It was really good. If I'd known that's what you wanted, I would have made the points, but I'm just doing it from memory.
All right. Are we ready to proceed, Mr. Ramos?
Yes, Judge.
All right. With respect to the pre-sentence report, has everyone had an opportunity to review it?
Yeah.
I have.
Okay. Are there any issues with respect to it?
Your Honor, there's the objection to the obstruction of justice enhancements, which I said before.
Right. I'm not going to have an obstruction enhancement. Yes, Mrs. Buell?
And Mr. Buell has read it.
Judge, also, I had written a letter about enhancement for physical contact.
There's not going to be an enhancement.
Thank you.
Any other issues with respect to the pre-sentence report, Mr. Ramos?
No, Judge.
All right.
Well, Your Honor, there's suborn perjury, and that didn't happen.
Well, there's not going to be an enhancement.
She's no enhancement.
Oh,
All
she
right.
said no enhancement?
So I'll direct that the pre-sentence report, together with the submissions, be placed in the record under seal. All right. Now, you wanted to be...
She directed that the pre-sentence report, which recommended that Franklin and Glendora be put in jail for 4 months for something that they didn't do, and in addition to that, be confined to their home for 4 months. But this is United States Magistrate Judge Joan M. Azrak, and she ignored all that. These were the recommendations of the probation department, and I imagine that they did pretty well what Ramos wanted them to say. And who is Ramos? Ramos is the United States, the U.S. Attorney. You can hear all right if if the people would enunciate clearly, but it's hard for you to hear when they don't. Okay, let's try some more. May I?
Yes.
Well, Your Honor, I'm going to take the position that there shouldn't be any sentencing at all. And I'd like first of all say that the words of our mouths and the meditation of our hearts, all of this be acceptable under God, our strength and our Redeemer. I would like to introduce my guests to the court. This is Mr. Robert Goldberg, Mrs. Barbara Goldberg, and Mrs. Cornelia Mason. We are opposed to the sentencing on the basis that we are innocent. Not only are we innocent, Your Honor, but we are victims. The real criminal is Kenneth Milworm, and he's been allowed to get away with it. We have tried 20 times to have Kenneth Milworm arrested. We have asked the U.S. Attorney's Office 20 times to have him arrested. It has not happened. And our charges, Your Honor, were stolen from us from the Nassau County Police. We had him all charged with double assault, criminal assault. Those were just stolen away from us. We did not assault Milworm, and I swear to you under penalty of perjury that I'm telling you the truth, the whole truth, and nothing but the truth. We never assaulted Milworm. He assaulted us. We are looking for justice. And it seems to me that the Eastern District of New York has to take pride in its work. It has to do its job. Its job is justice. Its job is to ascertain the truth. The truth has not been ascertained. Another thing Mr. Grossman said was that if the whole criminal action was nothing but retaliatory, it was vindictive prosecution because we, like Americans should, we chose to stand up for our First Amendment rights. And so we were picked out to be prosecuted for that. Now this is upside down. It was brought to intimidate us to drop our civil suit. It was brought to make us give up the reports, the exposures on TV, and it was brought to cover up the horrible double assault of Kenneth Milworm, pictures that you have seen many times, I'm sure. Did the court have time to read all of Glendora's submissions?
I did.
Oh, thank you very much for doing that. Again, I say, so we're against this sentencing because we are innocent people and we are victims. And I feel that the Eastern District has failed its duty to us, to the federal courts, to America, and to our God. And I feel that that's going to be a shame on the Eastern District for what has preceded this and what is to follow this, for predecessors and for progeny. And the taxpayer money that has been wasted on this is outrageous. It surprises us that nobody realizes what a terrible thing has happened here. You just don't sentence innocent people. Kenneth Milworm beats us up and we take the rap. It's decadent, it's corrupt, it's diseased, and it's sick. Mr. Ramos, did you ever tell a lie? And why didn't Mr. Ramos call Channel 12 News as witnesses? Was Glendora injured? Well, was an ambulance called? Yes, so Glendora was injured. Who injured her? Milworm is a victim of no crime by us. There are 50 conspirators involved. I have listed some of those conspirators. Some of the conspirators' names I have withheld, but I have listed most of them. A thing about the trial still bothers me, Your Honor, Magistrate Asrak, that I didn't get any rulings from you all the way from March till September, the day before trials. When I got your rulings, they were all against us. That didn't give me time to say that I wanted an Article 3 judge to do this. And then I didn't get a chance to sign the consent form until the very hour that we were picking jurors. And what has happened here in the Eastern District, Your Honor, is is what millions of Americans have given their lives for. As I pointed out, Franklin has offered his life for that. To get rid of Gestapo, to get rid of Holocaust. Somebody goes out and tells a lie about you. That's all it takes. Somebody goes out and they tell a lie about you, and you're put through 14 months of hell. That is not a good system. It's terrible what we're doing here to our country. For the sake of the Eastern District of New York, this thing should be stopped. For the sake of the United States of America, it should be stopped. There's nothing so simple that these conspirators can't make it difficult. All it would take is telling the truth. The whole thing would have been over in a day. Telling lies is an easy way to get out of it, a cowardly way to get out of it. But we're not going to do that. We will end up and we will always own our souls. I guess, let me say first that it's the Dreyfus case of the turn of the 21st century. The Dreyfus case happened at the turn of the 20th century. This is happening at the turn of the 21st century. The Eastern District has acted in bad faith. We are here to do good. They are there to do evil. We are looking for justice. We are getting injustice. And, well, I'll say again, they have to live with this all of their lives. 300 people are being naturalized today, downstairs. 300 people. All on the myth of liberty and justice for all. The upstairs is a different story. 1,870 lies. Did you receive Lawyer Graceman's letter? Mm-hmm. Oh, you did? Thank you. And does the Brooklyn Bridge go east and west? Mm-hmm. I just want to put out the cost. To me, it's been $2,200, 1,600 hours, $409,000 worth of legal labor, 8,000 pages of Bruiser Ken lying, 26 volumes, 2.5 file drawers, 29 TV chapters, a half an hour each, 113 mailings, February 18, 1997 to April 24th, 1998 is 1 year, 2 months, and 1 week. Of traitorship to the USA, 1,870 lies, and to Franklin it has been 215 hours, $490, and he has done some chapters on TV too. I want to thank the court for being so patient. If the court will only recall what the court said to Mr. Ramos on March the 29th on our first meeting, you said to him, we don't have many misdemeanors here. If I may have any time for rebuttal. Thank you.
Mr. Grossman, was there anything you wanted to add?
Most respectfully, Judge, I'd ask the court to consider sentencing Mrs. Buell to time served. In this case, I believe that her guideline calculation now is level 6. Zone A, which is a permissible sentence of 0 to 6 months. I believe that the sentence of time served, given the circumstances of this case, given what Mrs. Buell has gone through, given the fact that this is a lifelong citizen with no criminal history, and I think the court would be doing justice by so sentencing.
Mr. Ramos?
I don't know what Ms. Murray wants to say something.
Well, I was going to deal with one defendant at a time, so I thought you could just address yourself to Mrs. Buell.
Very well. Your Honor, with respect to Mrs. Buell, first of all, if I were a betting man, I would probably bet some money that this would not be the end of this particular proceeding, and accordingly, and for the record, we would state that for the reasons set forth in our letter of March 3rd, 1998, that the enhancements for obstruction of justice and physical contact found by the probation department are appropriate and should have been imposed in this case. With respect to sentencing, Your Honor, now that the guideline range is 0 to 6 months, I would simply ask that the court bear in mind in sentencing the defendant that throughout these proceedings she has steadfastly refused to accept responsibility for what she did, even in light of the overwhelming evidence which the government presented against her, the testimony of 6 eyewitnesses who were present for the incident. Moreover, during the entire time that this proceeding has been pending, she has gone on not only the airways but also in a number of legal pleadings filed with this court and other courts, maligning the very good names of some very good law enforcement officers and court security officers in a way which was gratuitous and in no way related to the facts concerning this case. And for all of those reasons, we would ask that the court not be lenient in imposing sentence.
Mrs. Buell, did you want to be heard in rebuttal?
Oh, yes, thank you. Steadfastly refusing responsibility is another Ramos lie and a misrepresentation. Certainly, I am not going to accept responsibility for something that I didn't do and that somebody else did. I have told the truth, the whole truth, and nothing but the truth. Always. And the other side has told nothing but lies. That's my rebuttal to that. As to the 6 eyewitnesses, they were all buddies and friends. There were no disinterested witnesses. There were no videotapes. There were no audio tapes. There were no fingerprints. And News 12, again, was not called to testify when they saw the whole thing. It is not on the airwaves. I am not on the air. I am on the cable. The legal proceedings here we have, again, the selective prosecution. I am an American. I have a right to address my government for a grievance of wrong. I have a right to stand up for American rights. I have a right to do what is right. And so that's just more persecution because I exercised and flexed Americans' rights. I'm through, Your Honor.
Okay, thank you. All right, I'm going to sentence Mrs. Buell first. I've heard everyone's remarks. I'm not going to sentence Mrs. Buell to any term of incarceration. I'm going to downwardly depart based on her age and the unusual family circumstances that we have. But I do view her conduct in this crime as serious. And I think the jury heard all of the evidence and they made a decision about culpability in this case, and I respect their decision. So I will sentence you, Mrs. Buell, on 97 CR 228-02 to 2 years of probation, a $2,000 fine that must be paid within 2 months, the mandatory $25 special assessment, and I remind you of your right to appeal this sentence. All right, now, with respect to Mr. Buell, do you want to be heard?
Yes, Your Honor. I would also ask that Mr. Buell be sentenced to time served in this case. First of all, the infraction here was very minor, not just because it was a misdemeanor, but because the very facts themselves were very minor. Nobody was hurt. Nobody was put in fear, and I would submit that the biggest injury was a bruising of Mr. Mildorm's ego on this particular day. In addition, my client's actions were motivated purely by his chivalrous intentions. He was acting, however mistakenly, out of a desire to protect his wife from injury. And I think that that's another factor that mitigates the seriousness of what occurred here. Most importantly, I submit that Mr. Buell has been punished enough by the prosecution. He is 78 years of age. He has lived a long, productive life. He's never been in trouble with the law. He has served his country in World War II and for many years worked as a journalist. It has been extremely traumatic for him at the age of 78 to be convicted of a crime. I'm not sure what will be served by putting this elderly man on probation. I think there is no reason...
On probation or in jail?
On probation. Your Honor, I assume if you're not putting Mr. Buell in jail, you wouldn't consider putting Mr. Buell in jail. But I don't believe that there's any reason to put this man on probation. I don't think there's any fear that he is going to commit this crime again. I don't think there's any reason to believe that he needs supervision in the community. For 78 years, he managed to live without harm to anybody and without any trouble with the law. And I believe that the trauma of this entire trial was punishment enough, and I would ask that you sentence him to time served.
Mr. Buell, would you like to be heard?
Yes, I would. It's hard for anybody to realize, but having something happen to you like this, at such an age, my wife and I, we are innocent. We have done nothing wrong. Mr. Mildworm has steadfastly refused to take any responsibility. He's in effect not told the truth. He says he didn't hit me. He didn't hit me. He hit me in the jaw and he knocked me down. And he grabbed my wife. He says we assaulted him. We didn't. So help me, I never touched him. All I did was when he approached my wife and grabbed her arm and inflicted bruises, I stepped between them. So I didn't know what he had in mind. All he had ever said was, "You've got to leave the courthouse." He didn't give any reason. And then he approached us, and without another word of explanation, and I simply, seeing what was happening to my wife and not knowing what the consequences might be, what he was intending to do, I stepped between them. I put my arms out to protect her. He says I punched him. Never, never, never. He says my wife touched him and impeded him in his duties. Not so. She's no more guilty than I am. We didn't do anything. The point has been made about the witnesses. They were all in-house people. There wasn't a person outside. And then sometimes if you read the testimony closely, they don't agree on what they said. Another unsettling part of the incident was the way the FBI treated us. And the way the U.S. Attorney's Office handled things. The FBI called us and said, "We'd like to have you come over to Uniondale," knowing of what had gone before, that we had tried to get action against Mr. Mildworm, and they led us to believe that they were going to try to help us take action against Mr. Mildworm. They got us to Uniondale. They took us downstairs, slammed the door, and said, "You're under arrest." They had a warrant, a trumped-up warrant, which included no oath or anything. It wasn't based on any facts. They had the warrant. Why did they have to get a warrant? If they had a summons, we would have been there. They treated us like criminals right from the start, right from the very start. They treated us like dirt, and that continued through. The trial was unfortunate, as I say. The biggest thing was the selection of witnesses. They were all people who worked in the courthouse or something. They all knew each other. And they all put together this story that upheld Mr. Mildworm, and which is far from, it's not the truth at all. It's not the truth. And it's been 14 months at the end of a person's life. But when it was, it seemed so needless and pointless, and we didn't do anything. We went to the courthouse to our business with the clerk. We gave them our recorder the way we should. We put it down there, and they said we wanted a receipt, which we received in other courts. And they said we don't give receipts, and they were belligerent right from the beginning. Mr. Mildworm and all the rest. It hurts. Let me tell you, it hurts. Thank you.
Okay, thank you, Mr. Buell. Anything, Mr. Reynolds?
No, Judge.
Okay. All right. On calling United States versus Franklin Buell. I am once again going to downwardly depart based on Mr. Buell's age, and I'm not going to sentence him to any term of incarceration. Rather, I will sentence him to 2 years probation, a $2,000 fine to be paid within 2 months, the mandatory $25 special assessment. And Mr. Buell, you have a right to appeal this sentence. Thank you.
Cause for waiver of speedy indictment 98594M, United States versus Lazard. Counsel, please state your...
On to the next victim. Was there a tremble in her voice when she sentenced this innocent man, this good man, this perfect man, to 2 years probation, $2,000 fine, and $25 assessment, whatever that is? So that's what happens to Franklin. He gets punched in the jaw by Bruiser Ken and gets sprawled onto the floor because he stretched his arms out between Glendora, his wife, and Bruiser Ken, the madman. So for that, Bruiser Ken gets nothing, and Franklin gets 2 years of probation, $2,000 fine, and $25. Now, were you able to hear everything that Jane Ann said? Jane Ann Murray is a legal aid lawyer, and she is Franklin's legal aid lawyer. She said a very brave thing, I think. She said from the beginning that Mr. Buell shouldn't be sentenced to probation, that he should be sentenced to time served.
had a great job. Money in the bank. Last month, someone asked if I read the Bible. The Bible? I'm successful, I'm happy. What do I need the Bible for? I can get more from the Wall Street Journal. But that made me curious. So I decided to take a second look.
I'm on my feet all day. When I go home, I just want to turn on the TV and relax. But read the Bible? All those these and thous and begats? Who wants to struggle with that after waiting on customers all day? But then a friend showed me this version written in modern English, and I was surprised.
This guy I play hoops with said I should start reading it, the Bible. Man, I said, I don't need no Bible. I mean, it just ain't cool. So he goes, I read it all the time. And he beat me by 20 points. So he gives me his Bible. I read it. It ain't hoops, but it ain't bad.
What's your excuse? Before you make an excuse to avoid reading the Bible, stop. Take a second look. Pick up the Bible for 5 minutes, and you may pick it up for a lifetime.
Rosanna, Joanne Freya, and Jane Doe, court stenographer, to dismiss my complaint against them for violating our 14th Amendment right to equal protection of the law. Now the other three defendants, John Porzio and Friedrich Lehrman and Margaret Guterman, have not appeared. They are in default. And a motion has gone to Judge Sweet for default judgment in my favor, $23 million. They have not appeared. They have failed to defend themselves against the complaint. So that's one lawsuit. The atrocious mess that Rosanna Washington made of this case, this baseless action brought by John Porzio, because on December 18, 1997, John Porzio spit in my face. John Porzio violated our warranty of habitability. John Porzio violated our right to peacefully hold, that's a split infinitive, to enjoy peaceably. The atrocious mess that Rosanna Washington made of that is in the appellate term Supreme Court of the state of New York. And the judges on that are Andrew DiPaolo, who lives in Glen Cove, Louis Palella, who lives in Greenberg, and Andrew Ingracia, who lives in Goshen. Before them is a motion by Franklin and Glendora that the appeal be on the basis of the law, a matter of law, and not as a matter of fact. The minutes, because of rip-off court stenographers, greedy court stenographers, are out of sight. We cannot afford them. That, of course, is a rank violation of civil rights. But Rosanna and Lehrman and Porzio and Guterman broke enough laws, and also Freya, broke enough laws to make the appeal stand. All kinds of laws. No in personam jurisdiction, no Travis hearing, no trial by jury, on and on and on. One law after another, maybe about 30 of them. Real property actions and proceedings law, real property law, all kinds of laws. They don't know the laws. They certainly don't know the laws of the unified court system of the state of New York. It's an atrocious travesty of a court. Anyway, that's where that stands, and we have not had a ruling from the appellate term, 3 judges on that. So that's 2 of them. Now we have Glendora versus Ponio, Lynch, Pataki, Porzio, Lehrman, and Guterman. Well, that cause of action is about Ponio told a lie. Before Ponio, we brought the case that John Porzio did not renew our lease, and he has to renew our lease. We are protected by the emergency tenant protection law, and he has to renew our lease. So we complained to the guard dog of the emergency tenant protection law, which is the New York State Division of Housing and Community Renewal, for short, BHCR. And Mr. Ponio said that he couldn't rule on the lease renewal because the matter was before the White Plains City Court. Take your choice. It's either ignorance or it's a lie. I choose to think it's a lie, because the matter of lease renewal was never before the White Plains City Court. Another thing that Mr. Ponio did is that he made a decision on November 21st and never notified anybody, or at least never notified us. So Glendora sued him and sued his boss, the acting commissioner of the Division of Housing, Mr. Lynch, up at Albany, and sued Mr. Lynch's boss, the acting governor of the state of New York, George Pataki. Now, and also, of course, Porzio and his lawyer for hire, Lehrman, and his lawyer for hire, Guterman. Now, Mr. Pataki has not appeared. The crazy people down at the DHCR got out the dumbest answer that you ever saw. Anyway, an answer, you know, is a boilerplate answer to a complaint is what more than one judge has said is the most useless piece of paper across the bench. So these screwballs down at the DHCR at 25 Beaver Street in Manhattan got out this so-called answer, and it was written by a so-called Mark Tyler, whose boss is a so-called Hirsch. And it was just silly. It was so silly. And it's taxpayer money. And so naturally I refuted that. It's a piece of trash. And they didn't think that I would know the difference, but Governor Pataki cannot be represented by an attorney for the New York State Division of Housing and Community Renewal. Governor Pataki has to be defended by the Attorney General of the state of New York. So in effect, Governor Pataki is in default. He has never appeared, he's been served, and he never appeared. On Wednesday morning, Guterman, Lehrman, and Porzio have never appeared. They have never answered the complaint. So on Wednesday morning, the 29th of April, we had a conference for James R. Cowie. And to stop discovery, because they don't want you to know the truth, finally they realized that Governor Pataki has to be represented by an Attorney General, and a very bad Assistant Attorney General is representing him, named Richard Lombardo. He lies, he's crooked, and I came out of the courtroom and told him that he lies, and guess what he did? He ran into the men's room. But anyway, he lied all through the conference, and I tried to stand up for what was right. And in order to get rid of the discovery, you know, the disclosure, he made a motion to dismiss my complaint. And that motion was granted. That was a very bad thing to do. However, and the return date on that motion is May 20th. However, the answer to that is that I will make a cross motion for summary judgment as a matter of law in my favor. Why is it a matter of law? Because the court chose to ignore the facts. How did the court choose to ignore the facts? By staying discovery. The court didn't care about the facts. Okay, then we'll go with the law. And we'll go with the laws that Ponio broke. Lynch broke because, and Pataki broke because they were both informed as to what Ponio had done and done wrong. So that's where that one stands, and I am writing my cross motion now. I started it this morning. And then we have the case of Porzio, who stole half of our security deposit. Not only did Porzio lie under oath in court before God maybe 13 times. And not only did Porzio commit suborned perjury and make Caesar, Eurythia lie, and other tenants lie, but he stole half of our security deposit. So therefore you have Glendora versus John S. Porzio and his liar for hire, Friedrich Lehrman, and Friedrich Lehrman's liar for hire, Mark A. Guterman. That's lawsuit number 4. Where does that stand now? Well, that's an easy one. Porzio, Lehrman, and Guterman are all in default. They have not answered the summons. They have not answered the complaint. It is before Justice of the Supreme Court, Louis Barone, and Glendora has made a motion for default judgment to Justice Barone. That's where that one stands. That's number 4. And the last one is Glendora versus Rosanna Washington, because Rosanna Washington robbed us of our right to trial by jury. The New York State Actions and Proceedings Law, the Real Property Actions and Proceedings Law, Section 745, says that we can have a trial by jury, and we demanded it. And both Joanne Freer and Rosanna Washington very crookedly, very deviously ignored that demand and that right. And where is that? Well, that went to the United States District Court, Southern District of New York. It was dismissed. I appealed it immediately, and it went to the United States Court of Appeals for the Second Circuit. And that's where it stands now. I am waiting for them to grant my informa pauperis, which is, it's just carte blanche. It's just the way it is. So they should be granting the informa pauperis, and then the appeal should proceed. I have not had time to picket 77 South Lexington Street, down with Joanne Freer and down with Rosanna Washington, and to tell the public about them. And also, I haven't had time to go to the Common Council of the City of White Plains and ask them to recall Joanne Freer and Rosanna Washington. Let's get them straight, Glendora. Rosanna Washington and Joanne Freer. I have not time to do that, but those are not, they're just on hold. They are not forgotten. And now, from time to time, while we're waiting for all of these litigations to be resolved, 5 of them, we are going to play you the evidence that Rosanna Washington and Joanne Freer robbed us of. This is the evidence that shows that every witness brought by John Porzio and his liar for hire, Friedrich Lehrman, lied. The videotape has the truth. And there's 8 hours of videotape evidence, and there's 5 hours of audio tape evidence. So from time to time we will play you some of that, and I'm going to play it to you now. First of all, I'll tell you a joke. A foreman of a coal mine hired an Irish man, an Italian man, and a Chinese man to help him out. And he told the Irish man, your job is to take the big chunks of coal out of the mine. And he told the Italian man, your job is to break the big chunks up into little chunks. And then he said to the Chinese man, I am going to put you in charge of supplies. So the foreman went away, came back in the afternoon, the Irish man had done his job, the Italian man had done his job. He says, where's the Chinese man? And he said, we don't know, we haven't seen him all day. He went into the mine. First thing in the morning, we haven't seen him all day. So the foreman went into the coal mine, and he's going down a very long, dark, narrow corridor. And the Chinese man jumps out and says, supplies! going down a very long, dark. April the 22nd, 1993, and it's Thursday. Fade. Wednesday. Okay, that is Roberta Walsh, and that's Candy Alpucci. And the son is the younger son. And the other one was Jamie Walsh. And the time is... what time is it, please? 1993, I'm in the cellar at 21 Greenridge. I would like to have you see my rugs that have been taken off of the cellar floor and put in the trash can. The suspect here is Candy Alpucci. I'm going to go over and take these rugs out so that you can see them. That's one. And then I'll take you around to the part of the cellar where I had the rugs. And in doing this, this suspect deprived the rest of the tenants the use of the trash barrel. Of ours. And that's it. Now these rugs were taken from the area in front of our locker where we had the rugs and put in here. Okay, now let's count the rugs. It's one big one, great big one, and then the little companion rug, and then 3, 4, and 5. It's May the 3rd, Friday, as you know the time is 6 p.m. Okay, you just should have heard what Waltz let out with. At 6:15 p.m. Friday, came up blowing his horn.
Hey, get my good side, will you?
And he was vile.
Bubble butt bastard.
Okay, good.
She calls our kids a brat. Goddamn lunatic.
Okay, this is Walsh, Daniel Walsh.
You're gonna intimidate us.
And it's May the 7th, 1993, Friday. This is Daniel Walsh.
On your ass like you did in all your other places.
Daniel Walsh.
Glendora doesn't like confrontation.
Daniel Walsh.
He's writing about our kids' play.
Okay, that's Daniel Walsh's car.
You're a sick woman.
That's Roberta Walsh, May the 7th, 1993, Friday. Time is about 6:10 p.m.
She's gonna rule the day.
I'll get you updated, you bitch.
That's Roberta Walsh.
Get away from the window and stop bothering people Michael?
Roberta Walsh. May the 7th, 1993, and that's James Walsh.
Okay, you can play there. You can give me one. I know. Free country. Yeah. Maybe a shirt, dude. Oh, well, like, I have to wait till later. I just got home. Yeah, I just got home.
Saturday, and the time is, just a second, 9:45 a.m. 2 minutes ago, I was picking up the litter that irresponsible people strew about the public property and the private property, and I was picking up a cigarette butt, a Salem cigarette butt, and Mrs. Walsh, Roberta Walsh, called from her window upstairs saying, "Oh, leave alone, idiot." Date is May the 8th, 1993. Franklin was washing the car, and she accosted him, and we have not spoken to her, and he is not speaking to her. She just came out of the blue. She just came out of the blue and did this.
She's taking me and I'm taking her.
It's just one accost after another.
My son is going to play here.
Okay, this is her son, James Walsh. Okay, let me give you an exact time on that. 2:16 p.m. It is now. It's about 2 minutes later. The son is refusing to play ball, and she's egging him on to play ball. At 1:55 p.m., this man drove under our southeast bedroom window and blew the horn. And the other two Apulchi boys are around. That was Daniel Walsh, and that was at 3:05 p.m. And that was May the 11th, 1993, Tuesday. And he said, "Hey, thanks for the letter. And thanks for name and name. I appreciate that, Fatty." And we were sitting in our bedroom, and he did this through the open window. Not only do you get accosted if you go outside, but sitting in your own home, you get accosted. They have these great bursts of noise, and they run off. And I see the camera. Greenridge Avenue. This is 21 Greenridge Avenue. This is the entrance to apartment 2A. And this little kitty is Ginny Cat. And as you come into the door, to the right is the kitchen. The kitchen looks to the west. And in the afternoon, you really see some nice bright sunshine. This is a superb range. This is a great big Magic Chef. And this is a great big hot point. That's a hot cat. Here's a closet here in the hallway. And this is the living room. That's the window that looks to the east, and that's the window through which the older Al Pucci looks every time he walks by. And these windows face to the west. Excuse me, this window faces to the south. This window faces to the south, and that's where the older Al Pucci looks every time he goes by, the older son. In the afternoon, these windows are just full of cheer and light from the west. It's really a beautiful exposure. Now I'm going to take you to the, this is the hallway. And this is, this room is, this part is facing north. This part, of course, is facing east to the courtyard. I'll take you outside later and you can see the courtyard. This is the CompuTemp, which gives the time and the outdoor temperature and the indoor temperature. And it also has a memory, and it'll tell you what was the lowest temperature during the day and what was the highest temperature during the day. These are some of Franklin's trophies and accolades as a reporter for the Buffalo News for 27 years and 10 years before that for the Springfield, Massachusetts Union. This is a gift from CBS TV when Glendora was on the CBS television network on Family Feud 10 times during Christmas and New Year's of 1992. What's in these boxes majorly are videotapes, commercial videotapes, 1-inch videotapes, 2-inch videotapes, 3/4-inch videotapes, 1/2-inch videotapes. Now I'm going to show you the bathroom. The bathroom looks to the east, and it is through the windows and the southern windows that all the noise comes. I'll show you the courtyard out there so you can see where the noises come.